Please be seated. All rise.
The Supreme Court, of course, has, in a unanimous decision, turned down a request by the petitioner, in this case the 2020 presidential candidate of the NDC, Mr. John Dramani Mahama, former president, to be allowed to inspect documents in the custody of the Electoral Commission. In this case, the first respondent, of course, these documents that were relied upon by the EC to announce the results of the presidential elections across all the polling stations, all constituencies, and at all regional level, and at the National Coalition centers across the country. Of course, earlier in the morning, the lead counsel for the petitioner, Mr. Chachu Chikata, had made his case to the court, he argued that having access to the documents would ensure that there is a fair determination of the case. He referred to fairness and transparency. These were the two major words he used in trying to argue out his case and why the petitioner had to be allowed to inspect those documents which are in the custody of the EC. Well, he did also insist that it has been established during cross-examination of Mr. Johnson Esiedun Ketia that some areas had multiple summary sheets showing different results. These were some of the issues that lead counsel for the petitioner, Mr. Chacho Chikata, raised. Counsel for the first respondent in this case being the EC, the counsel for the EC, Mr. Justin Manuvro, as well as the counsel for the second respondent, in this case, Mr. Akoto Ampao, both of them opposed, they objected to this application by the petitioner. They insisted that the court applies its decision on the same issue in 2012, during the 2012 election petition, which actually happened in 2013, where it denied a similar request. And it's instructive to note that in 2013, it was the second respondent, in this case, Nana Adodanke Kufuor, together with Dr. Mahmoud Baumia and the late Jake Obichevi Lamte, who were the petitioners. They today, Nana Adodanke Kufuor is the second respondent in this matter, and during the 2012-2013 election petition, a similar case was brought to the court, and the court denied access to the documents by the EC. Now we are approaching the days where usually the press conferences after the daily sittings are held, as the spokespersons for the legal team of the petitioner, in this case being led by the former Attorney General, Madam Marietta Pia Opong. So spokespersons for the legal team of the petitioner are now about to address the press.
Okay, good afternoon. Today there was one main purpose for which we were in court, and it was to deal with an application we filed asking the first respondent to produce for inspection certain documents. Now, this was founded on a request we made to the first respondent on 19th January 2020, that the first 2021, sorry, that the first respondent should produce for our inspection the constituency and regional collation sheets, the regional and constituency summary sheets, as well as Form 13. We also wanted to find out from them the basis for the different corrections that they had made. So we filed an application, and our counsel made it very clear that the reason for which we are asking for all these sheets is the fact that, yes, we have, for example, the constituency and regional sheets. However, we need to know the basis for the different figures that the EC keeps coming up with. You recollect that there's a figure of the 9th declaration, which was quoted as the valid votes. There's the alleged correction that was made on the 10th. There's also the figure of 13,121 plus, which they quoted in their paragraph 24 of their answer, which was a sort of acknowledgement of what we were saying in our petition. So they've come up with different figures. We don't know the basis for which they have come up with those figures. And therefore, we needed to see the originals of those documents to be able to make our own assessment before we cross-examine the first respondent's witness. Unfortunately, the Supreme Court did not agree with our request. It refused our application on the grounds that these are documents that are in our custody. But, well, the Supreme Court has ruled. There's not much we can do, but we disagree with the fact that all these documents are said to be in our custody, and therefore we are not entitled to it. You heard the two witnesses that have testified so far. Both of them, for example, have said the Form 13. They have never seen or signed the Form 13. And that is at least one document that we don't have in our custody, the most important document of all. We've never seen it. Again, we've made it clear that we were not part of whatever discussions happened at the EC when the different corrections were made. And therefore, we need to see the basis for those corrections. Well, we've been denied that opportunity by the court. But that's not the end. We'll still continue with our case. Questions?
Counsel, at the close of proceedings yesterday, Mr. Chikata had indicated that depending on whether this request was granted or not, it may determine the possibility of calling another witness. We saw at the close of proceedings that another request was made about a potential witness. We know we are not supposed to know the specifics of that particular decision, but we just wanted to find out, is it a case that you are going to call another witness, or has that request been granted and you don't have to file a witness statement for another witness to come?
As you saw, I did not enter the room with the counsel and the judges. We are not privy to that discussion, and it's not for public consumption. That's why it was held in camera. You notice that when His Lordship, the Chief Justice, came and adjourned the case, he did not give any details. I do not have the details either.
All right. We know that he who alleges also bears the burden of proof. You have come to court without certain facts that prior to filing the case in court, there were some communications put out there to suggest that you did have all these facts. Indeed, today we get the impression that this application was an afterthought. You were not prepared for it. You had 21 days to have been able to put all these facts together. Why didn't you do that earlier on? Was it an afterthought?
You're entirely wrong. Maybe you misunderstand our case. We have stated clearly what our case is, and it is based on the declaration of the EC. Based on the declaration of the EC, that no candidate got more than 50%. It's based on the fact that there have been so many corrections to that figure, which nobody knows the basis of. And that is why we say that the declaration is null and void. We have come fully prepared for this case. And in any case, the EC is supposed to be an impartial part of this whole election process. What do they have to hide? What prejudice will be occasioned to them if they produce the documents for us to see? None whatsoever. If you conducted your activities as EC chair, fairly, transparently, impartially, why will you not produce the documents for us to see?
I want to also ask about the impact of the application that was denied your side on the case going forward. Are we expecting to see you call another witness, or would say that based on what we have seen so far, the two witnesses you have already called are the witnesses you have to make your case with?
I think you've just asked the same question another guys. You all see what will happen on Friday.
Yeah, I want to find out how strong your case is now, looking at the number of applications dismissed by the court.
We still think we have a very strong case. We are very, very certain about the case we have before the court. Irrespective of the fact that our applications have been refused, we came to court prepared. We are ready to continue with the case, and we will go through with the case till the very end.
The case has been adjourned to Friday. On Friday, are we expected to see your side cross-examining Madam Jean Mensah?
The case has been adjourned to Friday. The Chief Justice did not tell us what is happening on Friday. We'll all see what will happen in court on Friday. Thank you. Chief.
You are for Yabedam was say Yabebo and Eddie C. Ewa court tofa ewu trika semua. Nina ne say and yabaye your lawyer at the ebisade to Supreme Court no and him say on share the first respondent the Electoral Commission of Ghana. Na enkrata omugina so at the ebobo aba it declares Omampenye Kufuado now winning the 2020 presidential elections no omon famra court na afafa ni nyina atimi ahwehwem ahwese enkrata ni nyina dimu a bibia ededa nakwam enti eno ho arguments enenne ye lawyer Chachuchi Kata ya mutibi no na asem wo kan ye ne tofa bo mu nyina ne se sa documents aye ka ho asemi se court no anhye Electoral Commission for amoma mfa ma court ama ya anhwehwe mu a enya de a atentene ni betumi aye adwuma na yatumi ehu emmadodo a epiem ewo 2020 presidential elections ni mu na senti okasa ne se yakoto abato baako de bia da yete results for on 7th December 9th December Jean Mensah or returning officer or declare results no the figures be two dra what say or bosso or the total valid votes or the two dra in that declaration you know 13,434,574 kwansima adia chen ya na mami asanso asesana no e the figures for fraba the room 13,433,573 after the total valid votes in the another figure 13,119,460 ye be pie court so a no was answer the figure for fraba so figure original so they declare abanama Omampenye Kufuado no say there 13,121,111 let's just say according to lawyer Chachuchi Kata no figures no adoso ye nim the documents in krata isi agina so the figures we nyina eba it is a atentini ninti ni aba court no krenti ni aba court na ye pese pere yo ye adwuma dia ene ye ni die mu na o sere se court no be hye isi na o mode san krata na ba na ye nyina yetimi ahwehwem na sa request isu se bio enya no kre se eye ne ya na o make sa request no te se de ye nuanom e kan ye o ye sa request no true ade a ye friend no mutual discoveries as far back as 19th January senka we de e ma court krampo mam ya ye ho no mpenyifo so utimu fitati am wanku it is a wonya boni bia de ma ye hwe wo documents a wugina so de sa figures ahodo nyina bai but the nam say EC4 anti asienti enene wode sa bisade ebeto court no enim court no de natemu bai de mo kan ne say omo ne anya adwen nti enya de omo be hye EC ama omo de sankrata no aba court amayahwe because sa documents a ye pese EC4 de ba no ye woni nyina emra ne say at every level of the election process and there was say ye di be my agents na ehọ ena ni die mu ye ne court no enya adwen esan say we hwe dance a eda court na nim na bibia kire pefe say documents no bebre wo ha NDC for ye ni bi for example document a ye friend of form 13 enra yewra Dr. Pesa White dance mu ehọ ba asem wo be hwe a judge ba ko e de sa form ne kire no eye sa form no na G-Mensa and Electoral Commission for say, we about on who you mean in area, no, record ma will be a nya or so ma agents inside. Now, what Dr. Pesa White had done, say, what is a which you say? Some brand new poor no more, yes, I didn't know as agents, no money, because Naji Mensa dada or more, I'm on free was or money, the flag bearer of NDC, Kwaku Dinkita Humbi. It is out from 13, no, or when you could see in Humbi. Yan farm more crumpuna campus or Macasa sign a reason ni. Into your munibi, and for that matter, NDC nibi. In the hot ye nibium, ye ne caught in yardrin say. Documents are bisa any na you will be because clearly no ye need from 13 whether duplicate or original. ABM it can be correct to say oh pink sheet polling station will be constituency summary sheet will be regional coalition sheet will be yes but yenina the yenina will be a declaration we on the 9th no and wechi G-Mensa no kwa ne isi fu akwa kwahye kukuom asesa no ensesa omu ye nyina no so no ye gidi se ejina nkrata abi so omosesa ni we no masanso akosesa ni biem omasanso akosesa ni biem enti enkrata omu gina so de sa different figures na ba ne ye ni bi enti sa wokasa ye wo documents ni nyina adenti ne yesanso bi sa omo a na ni biemu ye ne wonya adwen because the foundation documents for the different figures they have churned out are not in our possession. It is a Nissan krata na. A sideng na ube hu se we na krata papa isi for you see na we nya papa. Na die twato. Ube kaya Eastern region coalition sheet e ho aba asem. Coalition sheet na koye mienu. Ni nyina isi for de omosa ahase. Ba isi for a kire se ba ko ye papa, ba ko nya papa. Say isi for anfasa our originals na omodi aye omo declaration and all the corrections na ma. A sit down at NDC, which of these two documents the EC used for declaration ye challenging. In the position for it is not the case is NDC for ye near dance ye bian yaba court ni yaba be ready. But ye na yaba court ye no kreni attention in the person ye juma. Na electoral commission ni motu a transparency, fairness and integrity. Now no na say why about to bibia da wo fan o mampenye kufu ado arene. Na fe fankrata ugina so di hu so mampenya kufu ado awene no bra na ye nyina ye hwe a wo se me ma wonfa wani kosua mponya dan enhwe ti we asem se ba ye begya ama Ghana fo na mo ankasa mabua ba ye de ye wogidie mapase no kre wohoi eye ba kope ase onyame kokruko itato we no kre wa asem we bia mu no ebepie whether or not this application has been granted or refused enti efie da court the share say emra ye beba so ye hwe ni mu say sanso no mu be hia bi meda mu nyina mase say mo bye thank you akade nyina unu ma dia pa let's go
So, colleagues, shall we go? Shall we go? All right, so good afternoon, and thank you for giving us some time to share with you a few of our thoughts after proceedings were adjourned today. Right from the onset, let me give you a little narration of the background so far. We have been in court because a petitioner, Mr. John Dramani Mahama, has invoked the jurisdiction of the Supreme Court that, among other things, upon a proper reckoning of the December 7, 2020 presidential election results, no candidate achieved above 50%. And therefore, the declaration as made by the chair of the Electoral Commission is in breach of Article 63, Clause 3. And from the onset, he indicated in his petition that he will be calling 5 witnesses who will be adducing evidence before this court to prove that indeed nobody got 50% plus 1. On the first day for his first witness, Mr. Johnson Asiedun Ketia, you all observed how, upon cross-examination, upon various scenarios, he kept coming to the same answer, 47% for the petitioner, 51% plus for the second respondent. We were informed that he intended to put a second witness in the box who adduced further evidence that nobody crossed the 50% mark. Dr. Kwesa White was put in the box yesterday. The crux of his evidence was that he and Mr. Rojo Metonunu were deceived by the EC chair with an instruction to leave the EC premises during the collation. And upon further cross-examination, he admitted that the EC chair could not actually instruct them so to do. We have been waiting for the evidence or further witnesses who will provide evidence that nobody crossed the 50% mark. This is the government of their case. Today, we were seized, or the court was seized with an application that was filed yesterday. And I heard our colleagues who just left say that this has been there for a while. It's not true. Check the date on the application. This application was filed yesterday. This application was filed yesterday. In fact, it was filed. It was served on us yesterday, but it was filed the day before. So this claim that this application had been put in way ahead of time is not true. That's why you heard our counsel talk about 34 days after the initial application. But be that as it may, this application is aimed at giving the petitioner an opportunity to go and inspect some documents. Inspection of documents generally is allowed in litigation. But it is not a matter that you have as of right. It is at the discretion of the court. And you have to convince the court or establish something before the court for the court to grant it. You have to prove that there is some necessity for you to be given leave to inspect those documents because, among other things, it will be necessary for the fair disposal of the matter. Without it, there will not be a fair disposal of the matter. And that it may also be necessary to reduce the cost of litigation. You heard Mr. Chachuchikata on his feet for about an hour trying to establish the necessity for which they should be granted leave to inspect these documents. And you heard counsels on the side of the first and second respondents argue that no necessity has been demonstrated because all of those documents are already in the custody of the petitioner. And the petitioner has not demonstrated before the court that there is anything wrong with the copies that he has, and therefore asking to inspect the originals. Because you have the documents already. Indeed, some of those documents were attached by the petitioner himself to his petition, some of the witnesses as well to their witness statements. And so the principle, the legal principle of necessity for fair disposal of the matter has not been demonstrated. And there has been no argument even made about a reduction in the cost of litigation. We also noticed, principally, that as the case moves on, and particularly with this application, the petitioner is now seeking to invite the court to breach a time-tested rule in litigation that he who alleges must prove. You come to court with your own case and your burden of proof is on you. It is when you have satisfied what we call a case, you have made a case in law, that the burden of proof now shifts onto the respondents or the defendants to respond. Indeed, if by the time you are done, and for those of you who are court correspondents, you know, if by the time you are done submitting what you think is a case, the legal threshold of making a case under the law has not been made, the respondents or the defendants have the opportunity to move a motion for no case because you have not made a case. So it is when you have moved a case and satisfied the legal threshold that the burden of proof shifts. We are observing that this is an attempt to shift the burden through the back door. Now, the court, as you observed, rose to consider the various arguments and came with a ruling. Before then, plaintiff had made an argument that if you have nothing to hide, why don't you produce the documents? Those documents are even on the internet. They have been published already. They are within the custody of the petitioner. So don't be swayed by this propaganda line that if you have nothing to hide, why are you not producing the documents? The documents have been made available. They are already in the custody of the petitioner. They are in the custody of all other political parties or candidates who took part in this election. They are in the custody of the second respondent, and they have not demonstrated any necessity for it. In the end, the court ruled, and I just want to quote what the court said through the respected Chief Justice. Said the applicant has not demonstrated the necessity